My name is Carl Pearson. I'm a New York attorney, a graduate of Harvard Law School, and represent homeowners, small businesses, and others throughout the United States in foreclosure defense, quiet title actions, wrongful foreclosure actions, and other foreclosure matters, customarily to make the mortgage more affordable with a loan modification agreement including any principal reduction. This video 104B, entitled How MERS Operates, is the second in a series of 12 related videos. The videos are being prepared for viewing in sequence from A through L. MERS is owned today by 23 financial institutions including Bank of America, Citi Mortgage, Wells Fargo, GMAC Residential, Freddie Mac, and Fannie Mae, which means that the U.S. government is also an owner or financier of most or all of the lender members, but it has thousands of additional members. MERS was incorporated in Delaware, that is, in 1997 under the name Mortgage Electronic Registration Systems, Inc., which became known as MERS. In 1999, it changed its names to MERS Corp. Inc., and in 2012 to MERS Corp. Holdings, Inc. Its principal office is at 1818 Library Street, Suite 300, Reston, Virginia, 20190. Note that MERS website states that MERS Corp. Holdings, Inc. is the parent company of Mortgage Electronic Registration Systems, Inc., so be careful if you bring suit that which entity, and you may have to name both if you're trying to sue, because it's not clear, as I see it, which entity is the one that's responsible here. MERS business is described by MERS as follows. MERS Corp. Holdings, Inc. is a privately held corporation that owns and manages the MERS registration mark system and all other MERS registration mark products. It is a member-based organization made up of thousands of lenders, servicers, sub-servicers, investors, and government institutions. Mortgage Electronic Registration Systems, Inc., that's MERS, serves as the mortgagee in the land records for loans registered on the MERS system and is a nominee or agent for the owner of the promissory note. The MERS system is a national electronic database that tracks changes in mortgage servicing and beneficial ownership interests in residential mortgage loans. Now, you heard what MERS says that it is. MERS has 13 officers and about 50 employees, but the real work is done by the thousands of financial institutions that make use of MERS. For a fee of only $25, an officer or employee of any of the member institutions can be provided authorization to sign documents on behalf of MERS, even though such persons are not officers, directors, or employees of MERS. MERS was founded in 1995 to enable its member banks to know who owned notes and mortgages because the county clerk's offices throughout the U.S. were slow in recording documents, often taking many months before the ownership of a note and mortgage became a public record. This alone was not a problem, other than perhaps a prohibited antitrust conspiracy and restraint of trade or an attempt to monopolize a line of commerce prohibited by the Sherman Antitrust Act. The real problem for homeowners and other mortgagors in the United States was the copying of a highly successful securities industry feature into the real estate mortgage industry and, quote, securitization, unquote. This feature in the securities industry is known as, quote, street name, unquote, a reference to Wall Street. When the owner of 100 shares of stock wants to sell the stock may be held by his or her broker, quote, in street name, unquote. The most commonly used street name is Seed & Co. That's C-E-D-E ampersand Co. period, which is a firm acting as the record owner of securities held in street name for a large number of major brokerage firms and other financial institutions. Each stock brokerage firm either uses Seed & Co. or a different account for its street name holdings. Seed & Co. becomes the technical owner of the 100 shares of stock and enables the brokerage firm to sell and deliver the stock without having to wait for the owner to produce the stock certificates. By holding the stock in, quote, street name, unquote, the brokerage firm had the stock certificate under its possession and control and could execute the sell order immediately, knowing that it already had the stock in its possession for delivery shortly after sale. When selling the stock, the brokerage firm merely tells Seed & Co. to reduce its holdings by 100 shares and to credit that same amount to the purchaser, the purchaser's broker, or the street name of the purchaser's brokerage firm, which more than likely is Seed & Co., so that the shares aren't actually transferred to anyone. MERS recreated the street name concept for notes and mortgages. MERS became the street name and enabled the thousands of members of MERS to have their mortgages put into the name of MERS for assignment of the mortgage from time to time. Mortgages are bought and sold for various reasons, including the securitization process, and even after securitization takes place. MERS would be able to keep track of who owned the mortgage, and when a need to foreclose arose, MERS could be used by the actual mortgage and note owner as the named plaintiff in the foreclosure action, or could assign the note and mortgage to the loan owner or servicer to enable the owner or servicer to commence the foreclosure action. MERS was named in the original mortgage as the owner of the mortgage, as nominee of the owner of the note. And if MERS could be the plaintiff in a foreclosure action in the judicial foreclosure states, there would be no need for any further recordings and payment of substantial recording taxes and fees to the county clerk's offices in the 22 judicial foreclosure states. The recording tax had already been paid for MERS when the mortgage was first created, and each subsequent assignment of the note and mortgage during and after the securitization process escaped recording taxation in all 50 states. The involvement of MERS automatically raises various legal issues for a mortgagor, for a mortgagor seeking to defend against an actual or threatened foreclosure. For example, is an assignment by MERS signed by the lender's officer or employee valid under state law? Or was the alleged authority of the lender's officer or employee proven with a power of attorney? Or was the signature authorizing the power of attorney or the assignment a robo-signature? Or is there at least one assignment for which no documentation was created, with the resulting argument of a gap in the chain of title? These are just some of the issues that are legitimate issues to raise when questioning the standing of MERS, the servicer, the lender, or the securitized trustee to commence a foreclosure action or serve a notice of intent to foreclose or a notice of acceleration of debt. Actually, the entire securitization process, to the extent it results in hiding the real owners of real property in the U.S., and avoids payment of recording fees and taxes on assignments, should have been declared illegal at the outset. But at this time, the activities are part of so many millions of mortgages that to declare all MERS mortgages void and unenforceable probably would cause the collapse of all major banks, unless the U.S. government took them over or gave them $1 or more trillion immediately to shore them up. As a result, when in court, the standing issues are often, but not always, heard by lower court judges, and this is where MERS-related defenses need to be made. Information that's available at MERS. You may be able to find out if your note and mortgage were securitized by going to MERS.com with the borrower's name, property address, social security number, or the 18-number mortgage identification number that is with a MERS mortgage. If your mortgage was ever part of MERS, you probably will be able to find out who owns or owned your mortgage and who is or was servicer for the mortgage, the MIN number, and whether the loan is active or not. Also, you may be able to find out this information for any second mortgage, but this is as much as you will get. You will not be able to see any documents, yet it is a start. Don't forget Freddie Mae and Freddie Mac. You should also look to the Fannie Mae, and I meant Fannie Mae and Freddie Mac. You should look to the Fannie Mae and Freddie Mac websites for any information you could obtain from them. They have been active in buying and reselling home mortgages after they have been securitized and have gone into default. These two agencies now are owned by the U.S. government, for your information. I'm now done explaining how MERS operates, and you should go to my next video, 105C, entitled Securitization Explained. If you have any questions, please give me a call. My telephone number in New York is 212-307-4444. I provide free consultations and represent homeowners and businesses throughout the U.S. as to their foreclosure problems, including the saving of properties through loan modifications and principal reductions. My telephone number, once again, is 212-307-4444.